I'm the Director of Enforcement and Surveillance in the new Alberta Energy Regulator, along with my other colleagues here of being Directors of Enforcement and Surveillance. What does that mean? And that really means that we're responsible for all of those staff who undertake compliance assurance activities now on behalf of the Alberta Energy Regulator. And our goal as we move forward collectively together here is to turn around and bring greater efficiencies in the delivery of those particular activities so that ultimately we can have the goal of having greater effectiveness across all of the different sectors that we regulate. And so you'll see that in the titles that have been identified with the Directors of Enforcement and Surveillance of mining with Martin Pates, myself with in situ, and conventional oil and gas with Ron Wagner and Rob Borth. Before we actually get into the details here today, I wanted to just reflect a little bit on this really exciting time that we have and this collective opportunity that we all share. And it is very exciting, and it cannot be underestimated how exciting that is. And I want to share that by telling you a personal story that I kind of have that goes to demonstrate how excited I am about this. And I hope that a few of you will be able to resonate with that particular story. And if not, reflect over time and also come to feel the same particular way. And so I'll start with the story here, and actually involves some of my particular colleagues, and so we'll see if any of them can actually pick out who I'm talking about here. And so the way that it played out is we've been working on this project for a long time now, like almost over a year, since we kind of knew that this was going to occur and this was going to happen. And through that particular time, what we did is develop relationships. And we created great relationships between those former ERCB colleagues as well as colleagues from ESRD. And we looked at recognizing that we had to collectively do this together and bring everyone together. And so we quickly developed bonds and relationships. And so one day I showed up to a particular meeting, and one of my colleagues turned around and said, "Erin, like, I don't understand. Every time I see you, you've always got a big smile on your face." And he said something to me, and I was taken back a little bit by it. He goes, "Do you think I'm a joke?" And I said, "Well, no, not at all. I don't think you're a joke." And I kind of reflected on that particular comment. I was like, why do I feel this way? And I looked at that situation, and I feel that way because I feel like we're at this time or opportunity where I reflect back as a kid, and I'm in New Zealand because that's where I'm originally from. And so I would have grown up on the rugby pitch or in the situation of the soccer field or cricket pitch. You guys might be going to a hockey pond and playing hockey or something like that. And you're of that young age where you have a bunch of friends and they want to turn around and have a game, and you know you're playing the local kids, and you set up this game. And so one by one, these different people end up showing up, and you've worked with them before or played with them before, and you know they're really good. So, wow, here comes Marty. He's on my team. I know we're going to do well. Here comes Rob. Here comes Al Mont, another colleague. Here comes Wayne Boyd. Here comes Ron. And, you know, this big smile just comes to my face because I know we're going to do really well given this particular opportunity, and it makes me feel really excited. And so I hope that we can work together here, and you should recognize that you should be excited as well, because this really is a once-in-a-lifetime opportunity that we're presented with here. And everyone has a role to play in it, not only us as a regulator, but you as industry folk and the way that things play out here. So, as I said, I hope you feel excited at this time as well, or if not yet, come to be excited with what we're embarking on right here. So moving on to why we're here today, and that is to talk about compliance and enforcement and what we're doing with the compliance assurance program in the future here. Okay, so back in the summer of this year, what ended up happening was that the Responsible Energy Development Act got passed, and what that basically ended up doing is setting up one single regulator to regulate the energy resource activities that are in Alberta. Now, a lot of the talk at the particular time was to turn around and set it up for greater efficiencies in authorizations in that particular process. And that definitely is one of the main goals of the regulator. One of the other kind of indirect consequences of that is that it means that one single regulator is now going to deal with all compliance assurance matters that result from those energy resource activities. So rather than seeing multiple inspectors or compliance assurance staff, that will now be handled by one organization and fewer particular staff. So hopefully it'll make it simpler and easier in the future here. And so what they've decided to do is adopt a phased approach to this. And so the first phase was the passing of the Responsible Energy Development Act. The second stage, which has just occurred here, is the passing of a regulation that brings in the Public Lands Act and Part 8 of the Mines and Minerals Act, and under the jurisdiction of the Alberta Energy Regulator. And that means that we now have the ability to undertake compliance assurance activities as it relates to those particular rules that exist. In relation to the next phase, that next phase is going to be AER and the Water Act, and that is looking to be about in the spring of next year. And that's when those particular rules and requirements will come into the regulator, and we'll have the ability to assess compliance in relation to those, and where appropriate, undertake enforcement. So just to do a couple of introductory things here, when I refer to energy resource enactments, what I'm referring to are those traditional enactments that used to be with the ERCB and under our jurisdiction there, or under that jurisdiction there. And so that would be things like the Oil and Gas Conservation Act and its regulations and rules, the Oil Sands Conservation Act, the Pipeline Act, the Coal Conservation Act. When I speak about the specified enactments, I'm talking about 4 particular pieces of legislation: AER, the Water Act, as well as then Part 8 of the Mines and Minerals Act, and then the Public Lands Act. So what are we looking at doing in the future in relation to the compliance assurance program? Well, it does involve many of the very high-level components that previously existed, both in the ERCB as well as ESRD, and that is the fundamental components of education, prevention, and enforcement. And what we're going to do is better integrate those particular activities so that, as I said, we can ensure efficiencies are created in the delivery of compliance assurance activities, as well as make sure the particular regulated area is effectively regulated. So the education goal is one of the main particular components, and what that does is serves to increase knowledge of the environmental protection and management, our regulatory rules, and further educate on guidance how to comply with those rules and requirements, and clarify the consequences of non-compliance. And finally, what we'll look at doing is educate so that we promote continuous improvement in environmental stewardship as well as compliance with our rules under the energy resource and specified enactments. So what are some of those education activities that you're going to see us doing on a go-forward basis? Well, these are things like we're going to be issuing printed materials that speak to our rules and requirements. We're going to have information posted on our websites that, again, speaks to those requirements, helps industry know what the consequences are, how to be in compliant with them. We're going to be going out doing a lot of presentations up front to make sure that people are aware of those rules again, and hold operator awareness sessions, hold sessions like these to better educate people on the consequences of non-compliance. We're also going to be involved in a number of conferences and committees to make sure that those rules that are developed that are clear, understandable, and enforceable. We also will be involved in incident responses and participant emergency responses, and so that's exciting, and that's something that we previously did and will continue to do that. Also, what we will do is send out focused inspection teams to identify maybe areas of concern or risk, to better educate operators in that particular area to better deal with the particular risks that they're facing. And so working in that kind of collaborative relationship. The other main component of the compliance assurance program is prevention. And the main goal of these types of activities are to ensure there's shared responsibility between the AER, other regulated authorities, regulated parties, and the public. And so the task of the AER is to support compliance by building capacity within those people who are subject to the rules to ensure compliance with them. And in addition, what we will do is work with other regulated authorities to support industry as it identifies and addresses potential problems before they become environmental or public risk concerns. So some of the activities that we're talking about under this prevention goal are things like our inspections that we undertake, compliance reviews, audits, our voluntary self-disclosure process that exists, doing reviews of technical information to identify where trends are that might exist in operational performance. Okay, so the next main component is enforcement. And again, the goal of enforcement really is to ensure that there are consequences for non-compliance and that regulated parties do not benefit economically from the non-compliance, and that they have responsibility to remedy problems and mitigate damage before things occur. Okay. Enforcement includes appropriate actions to remediate, deter, and where appropriate, penalize those parties that are non-compliant. So our enforcement component will really serve as a backstop to our compliance assurance program, and when there are findings of non-compliance relating to our energy resource and specified enactments. Education and prevention activities will form part of our enforcement consequences and actions that we issue, and they will often be a formal mechanism by which these other activities of education and prevention are triggered. So that might be through the development of an action plan to better understand the root cause of a particular non-compliance, or circumstances where we may ask a regulated party to undertake a third-party audit to better understand their management systems and whether things are being set up where it facilitates actually non-compliance. So within the prevention component, what we are going to be looking at here shortly, and we've actually already started, is an initiative where we will be doing multidiscipline inspections. And so what this involves is sending out inspection teams, and we use the terminology of two in a truck. So what we're looking at doing is recognizing that we have this added particular jurisdiction, but yet not having sufficient knowledge where it can be housed in one particular person to undertake an inspection. So what we're going to do is, where there are energy resource activities with multiple authorizations, so situations where you've maybe got a big in situ operation and you've got an authorization that relates to been granted under the Oil and Gas Conservation Act, or maybe under the Oil Sands Conservation Act, as well as then maybe there's been a public lands disposition granted in relation to that activity. Then we will send out this multidiscipline inspection team. They will look at it as a whole and see, well, okay, how is the performance of that operation working in relation to our rules, and therefore respond one time in relation to a finding of non-compliance, as opposed to being the circumstances where we send out multiple inspection staff at different particular times, and industry then receives multiple enforcement responses because they've gone out at individual particular times. Okay, so it's part of that objective of creating greater efficiencies in the delivery of compliance assurance processes. So how are we going to decide whether it might be subject to one of these multidiscipline inspections? Well, it'll include a number of factors, but generally it'll be based on the risk to the environment and the public in relation to these operations, as well as the history of the regulated party. And you can see based on the title there that also those things that have multiple authorizations granted with respect to them will drive those types of inspection teams. And so when we subsequently get a peer in the Water Act, then we'll have what we're referring to as 3 in a truck. And so we'll have an energy resource inspector, public lands inspector, and then someone who's very knowledgeable and a peer in the Water Act and going out to one of these energy resource activities and assessing compliance as a whole and subsequently responding as a whole to any particular findings of non-compliance or educating or preventing the particular activities. The goal ultimately then, as we build capacity over time and knowledge, is to turn around and say, well, this will be able to be capable of done by one inspector and one particular person who will be able to go out to one of these particular operations and undertake that assessment. So what we've ended up doing here in terms of the future state of the AER's compliance assurance program, and in particular when we talk about the component of enforcement, we're looking to integrate things, and we recognize that there was a need to integrate things early on in recognition that we didn't want to be in circumstances where we would be going out assessing non-compliances and then subsequently industry being put in a position where they'd be subject to multiple non-compliances and subsequently multiple enforcement actions. So as a result, we've tried to integrate this compliance assurance program and process of enforcement. And what we've done is that we've kind of taken the best from both regulators. We both as the ERCB as well as the ESRD have a long history in regulation and have well-established compliance assurance programs. The way that we actually did enforcement was a little bit different under each particular program, and so what we're now going to have to do is integrate that particular approach. And so what I'm going to talk through the next few slides kind of provides you that insight as to how we go about integrating. So you will see components of the Directive 19 compliance assurance process. You will also see components of ESRD's compliance assurance program and principles document. So before we get into more detail with that, the first thing that I should say about the enforcement framework is that it does bring with it a number of additional tools that will be available to the Alberta Energy Regulator. And the one of probably most significance is the tool of administrative penalties, and they will now be able to be imposed where you have non-compliances under the energy resource enactments. So previously, our ESRD counterparts could turn around and issue an administrative penalty where there was a contravention of the Public Lands Act or Part 8 of the Mines and Minerals Act or PEER or the Water Act. Now, similar, the energy resource enactments, where there are non-compliances, we will also be able to issue administrative penalties. And that was done through the Responsible Energy Development Act General Amendment Regulation that gives the Alberta Energy Regulator that power. It sets out the specific non-compliances or requirements that we can impose an administrative penalty to. The administrative penalties can, at a maximum, be $5,000, okay? And it can also be applied for each day that a particular non-compliance exists, okay? There are a number of factors that can be used to determine the level of a particular penalty, and they relate to the steps taken by a responsible person for the non-compliance to avoid or limit the extent of the actual damage or potential loss from the non-compliance. It can relate to the compliance history of the regulated party. It can relate to if the non-compliance results in an economic benefit derived from being actually non-compliant. Then that will also affect the level of that particular penalty that can be imposed. So that's probably the most significant additional tool. All the other particular tools will come over when they're subject to ESRD requirements. So the applicable legislation will guide the enforcement response, and when there is a non-compliance under the Water Act, then there will only have the ability to turn around and issue a particular enforcement consequence that's available under the Water Act. Similarly, if it's under an energy resource enactment, we can only turn around and issue an enforcement consequence as spelled out in that particular enactment. And so you always have to go back to that guiding piece of legislation to work out the extent of your authority and power. So within the AER Enforcement Framework and this whole integration of our activities, what we've decided to do is we've gained some flexibility by turning around and what we've referred to as the enforcement investigation process and building that into the way that we undertake enforcement activities. And this process resembles very much what ESRD previously did in relation to findings of non-compliance. What it does is that it brings really a test of going, let's look at the individual circumstances, and let's not actually, in certain unique situations, predetermine what the enforcement response should be. We're going to look at the situation and go, what factors exist, and we're going to apply the most appropriate enforcement tool in that situation in order to, as it goes back to the original goal, to remediate, deter, or in some cases penalize the particular non-compliant behavior. What we've also done within the framework is maintained the efficiency, and this has been done by continuing on with the ERCB's predetermined risk assessment process, where it goes through a risk assessment of either being high and low, and then subsequently having a set process as to what is the particular enforcement response when it's high or low. And that will still exist within the particular model. So it's kind of exciting because it really does bring the situation where you can have greater flexibility, and when industries in a situation where you know, sometimes you might have looked at our predetermined model and go, that doesn't seem quite right. Like these circumstances didn't play out, so it seems like it should elicit a different response. Well, we now have that ability to go through that enforcement investigation model and choose the most appropriate tool. Alternatively, in circumstances where we want to quickly identify the non-compliance, get it addressed, and get it resolved, we will have the predetermined risk assessment model that exists. So what I want to do now is just go over some key features of the enforcement program that really will continue to exist. And as I said, we will continue to use the predetermined risk assessment process, the high and low non-compliance that exists, to be able to quickly and efficiently deal with non-compliances where that's the most appropriate process to go down. We're still going to use the most appropriate enforcement consequence in order to meet the overall objectives of the enforcement program. So where in circumstances that there's immediate risk to public safety or the environment, then there will be situations where we will shut in, and those operations will remain shut in until the situation where that non-compliance has been resolved and those risks alleviated. We will also continue to have the voluntary self-disclosure process. And so what will be really important here is that process will be applied, and as it relates to the ESRD requirements, the situation is that under the existing policy or practice is that you do not get coverage under the policy, or you do not get immunity to a certain degree from enforcement where a non-compliance has to be notified to the regulator. And this is indicated through statutory obligations that exist. And so when we look at the specified enactments, all, if not every, particular non-compliance has to be reported to the regulator. So in those circumstances, they're not going to get automatic, coverage under the voluntary self-disclosure policy. What I'll turn around and say is that they may actually, in reality, be dealt with in the same way as if they would get protection under that particular policy. And so it will really depend on the unique circumstances of those non-compliance to work out whether it's appropriate to address it in a way where, okay, there's risks that exist, we've got a mitigation plan that's in place, we're moving towards addressing it, and we can see that those risks are going to be alleviated. But there may be circumstances where the non-compliance results in a huge economic gain to the particular operator. And so where those circumstances exist, if you attempt to disclose them to the particular regulator, then they may be treated differently, okay, than getting coverage under the voluntary self-disclosure process. The enforcement investigation process is going to be a part of it, and I've kind of already spoke to that, so I won't spend too much time. The other thing is that there's no predetermined enforcement response under that process. So that's kind of key. Again, what we will do is to bring that greater level of flexibility, we're going to look at the individual circumstances and work out what the most appropriate enforcement tool is to use to ultimately assist with changing particular behavior and reinforcing those things that we want to achieve. Okay. So the last point here in relation to key features of enforcement is that the concepts of persistent non-compliance and demonstrated disregard that previously existed in the old ERCB kind of Directive 19 compliance assurance model, what we're looking to do is build this into the enforcement investigation process. So what you'll see here shortly is that there are a number of indicators or key things that will either drive something going down the predetermined risk assess process or going down the enforcement investigation process. And those indicators actually speak to the ideas and concepts of persistent non-compliance, and you'll see that reflected in a licensee's compliance history, or other circumstances of demonstrated disregard will be reflected where there are situations where something has been, a non-compliance has been committed and it's been done willfully or knowingly. One key thing to really emphasize here is that the objectives of the enforcement framework really continue and are the same. So it is still to be firm and fair. It's still to be timely, equitable, and consistent. We want to have appropriate and predictable processes. And enforcement tools will be selected based on risks to public safety, the environment, responsible development, and resource conservation. So as I've already alluded to, what we've done in order to better coordinate the enforcement responses flowing out from a single regulator and the different previous approaches of enforcement that were undertaken by the ERCB as well as ESRD. What we're looking at doing in the future is building this decision tree and these indicators that allow you to work out which process it's going down, and this will allow for efficiencies, as I kind of previously said, deal with the non-compliance and get it fixed and address those issues that exist, and in the circumstances of greater flexibility, and that will be utilizing the enforcement investigation process. So let's quickly talk a little bit about those factors. So the first factor that exists is whether something is predetermined and has gone through that, what people will know as the previous ERCB predetermined risk assessment process. And at this particular time, we all have our risk-assessed non-compliance that still exists in relation to the energy resource enactments. We are moving towards risk assessing those requirements that are under the Public Lands Act, and that will come out as situations where we can quickly and easily deal with those types of non-compliances. We will do the same thing as it relates to AER and the Water Act when those requirements and rules come under our particular jurisdiction. And that will then guide whether we end up going down that predetermined risk assess process or the enforcement investigation process. If it hasn't been risk assessed, then naturally we'll flow down this enforcement investigation process. The other key indicator is really looking at, has there been an adverse effect that's either occurred to the environment or the safety of the public, and where it happens in the context of a particular non-compliance, then again that will be an indicator to work out which process that it'll go down. If there has been a serious adverse effect that's occurred, then it's more likely going to move down the enforcement investigation process. And the regulator is going to determine what is the most appropriate tool to apply in this first instance here of finding of non-compliance. The next indicator is compliance history. And so this will be looking at our previous inspections, our previous audits, our previous compliance reviews, our performance reviews, and seeing whether there were satisfactory inspections or results out of those or not. And where they're not, then we will look at that, and again it will be an indicator whether we move down the enforcement investigation process or not, open up, I guess, more enforcement tools that are available in the first instance to better be able to work with industry and change their particular behavior given that particular indicator exists. The next thing is an indicator of failing to comply with a regulatory task where there's been an economic gain. And so I've sort of previously already talked to this, and that's a situation where there's clear evidence, and that's really important to kind of emphasize, that a regulated party has seen to economically gain over another regulated party. And where that is, by being non-compliant, and where that has occurred again, that will be an indicator and allow us to go down the enforcement investigation process, open up a kind of more elaborate, bigger toolbox to turn around and go, well, we might have to change this particular behavior here because it's not fair to industry players for one regulated party to economically benefit over another. The next particular factor is willfully or knowingly commits a non-compliance. And again, I cannot say enough that this relies upon a high level or threshold of evidence to make this out. So it's where it's deliberate, it's typically through written evidence or statements that are made that indicate that there was an understanding and knowing of the non-compliance that existed, and there was a positive, affirmative choice to go ahead and do it anyway. Okay, and so again, where there's evidence of that, it will probably move it down the enforcement investigation process, and again, open up a bigger toolbox that will be available to be used in that instance. So the final thing is that risk to the AER's regulatory framework. And so when we deal with risk, there are always varying degrees, and within our regulatory framework, there are requirements that are identified within the bigger kind of process or regulatory scheme of having more significance compared to others. And where that arises, and that will arise generally through our review each year, through our regulatory and strategic kind of area, to identify those particular areas and priorities, and that will again be an indicator to turn around and say, okay, this might be where we move down not the predetermined risk assess process, the low and high process, but we move down the enforcement investigation process and allow for a greater toolbox to be used in the first instance where there's been a non-compliance. So often very tied to enforcement is the idea and concept of appeals. And so I just want to spend a little bit of time here talking shortly about that particular process. And so what the regulator has decided to do is to really streamline and simplify the appeals process. And so what we are going to do is deal with every appeal matter under the regulatory appeal process. And so this means irrespective of whether it be an authorization appeal where there's been some sort of objection or a situation like that, or where there's a circumstance of an enforcement action being issued and a decision then is made to appeal that particular enforcement action, or maybe there's been a reclamation certificate that's issued and then subsequently someone looks at appealing that. It will be all dealt with under one particular process, and this is an attempt to, as I say, simplify and kind of streamline that appeal process. Some key things here in relation to that process is that Section 38 of the Responsible Energy Development Act is the authority for regulated parties to make an appeal or a request for a regulatory appeal. And so that's the important provision that you guys will want to know about and quote when you want to make such an appeal. A request for a regulatory appeal has to be done subject to the AER rules of practice. So you want to go to Section 30 of those rules, and it sets out what you have to submit and the different information and the kind of initial information that's presented. There, it also sets out the deadline dates for the filing of different appeals. And I cannot emphasize enough that you need to pay attention to those because they're different depending on the nature of the appeal that you want to do. So as it relates to enforcement actions, it really depends what type of enforcement action that's undertaken will determine how many days a regulated party has to file an appeal. Okay. So what will happen is that will come into the regulator. The regulator will determine whether the regulated party is an eligible person, and it's an appealable decision to be determined by the regulator. And so these terms or ideas are spelled out under the Responsible Energy Development Act. In most contexts of enforcement action, you're going to meet the test pretty easily. You're going to be an eligible person, because an eligible person generally defined is someone who's affected by a decision. If we turn around and issue an enforcement action, obviously that regulated party is going to be affected by that decision. The next test is the appealable decision, and this will come down to the idea of filing deadline times, as well as there are other things in there that talk to about the nature of the particular appeal. What are your actual grounds for appeal? Is it something that can be appealed or not? Is maybe the appeal vexatious or frivolous? Okay, and so the regulator will make those first prima facie kind of decisions that exist. Once that decision is made that a regulated party has a request for appeal that can be accepted, then what will occur is that under the new Responsible Energy Development Act is that there's a bigger emphasis on alternative dispute resolution. And so it'll kind of play out in three ways. You'll either have a hearing commissioner who will be appointed to conduct the alternative dispute resolution process through the appeal, okay, and initially try to resolve the matter. You may have a specific person who has alternative dispute resolution skills at the AER as a person to facilitate that process. And so they may be involved in it. The parties who are subject to the appeal, so the original statutory decision maker and the regulated party who's appealing the decision, could turn around and go, no, we're happy just to meet and discuss this and try to work it out ourselves. And that's quite acceptable, and if that's the way that it plays out, that will be accepted as the alternative dispute resolution process. Now, if the matter cannot be resolved through that alternative dispute resolution process, then it'll be set down for a formal hearing with a hearing commissioner. And they are an independent set of commissioners from the Alberta Energy Regulator whose specific task will be to hear these types of appeals. And as I say, they're appeals across all particular areas of authorizations, enforcement actions, as well as when we talk about reclamation remediation issues. And so that hearing commissioner will determine the type of appeal process that gets adopted. It may be written and provide submissions. It may involve some sort of oral hearing. It will ultimately depend on the nature of the particular appeal that exists. That hearing commissioner will then turn around and render a particular decision, and then as previously existed, regulated parties have the ability to appeal that decision to the Court of Appeal. So that concludes my presentation on compliance and enforcement.